going to talk about the Georgia Fair Business Practices Act. That's O.C.G.A. 10-1-390, as the lawyers say, et sec, which really means continued, because it's a number of code sections after that. One of the most important ones is 10-1-399, which requires the complainant under the Fair Business Practices Act to send a notice of the violation of the act and a demand in the notice. And then the defendant, or the person or business being accused, has 30 days to respond to the notice. Now, what a lot of people don't know about the Georgia Fair Business Practices Act is that the defendant can respond with a reasonable counteroffer or settlement offer, and if the plaintiff, the customer, in the case of a dealer, goes off and sues the dealer and wins at the end of the day, then the judge can actually limit the win to the amount of that counteroffer if the judge finds that that counteroffer was reasonable in light of the circumstances. Something a lot of people don't know. They don't know that they can do that. In fact, a lot of lawyers don't know that. The Georgia Fair Business Practices Act is, well, let's say this, I could do a whole semester class just on that act itself. It is the most common civil violation that I see with car dealers, meaning it is the most common lawsuit brought by customers, at least those that have attorneys. The pro se customers, those representing themselves who file in small claims court, they're not moving under the Fair Business Practices Act. But the ones that have a law firm behind them and a lawyer behind them are generally coming after dealers for violations of the Fair Business Practices Act. What is a violation of the Fair Business Practices Act? Well, this is one of my favorite things, or I should say least favorite things about the act. It covers any unfair business practice. What is that? How do we define that? Well, the legislature made in the act sort of a catch-all provision that says any unfair business practice. Now, plaintiffs' attorneys in car dealer cases have argued that disclosures at auction that aren't disclosed to the customer are an unfair business practice. Any superior knowledge that the dealer has that the customer doesn't have and the dealer does not disclose is an unfair business practice. And things like that, where there's something that the dealer is hiding from the customer in order to sell the car. They've argued that's an unfair business practice. When we talk about as is in a later video, we'll talk about how that applies, because a lot of dealers think, well, if I sold it as is, it doesn't matter what I say, it doesn't matter what I disclose, it doesn't matter how or what paperwork I use, as long as it's as is, there's nothing they can do. Wrong. The Fair Business Practices Act may still provide an avenue for a customer to come after a dealer, even in an as-is sale. That's the civil side. When I say civil, I mean that's the consumer versus the dealer in a Fair Business Practices Act claim. Now, one of the key components of an FBPA claim is that it does have to be in the consumer marketplace. So a finance company cannot sue a dealer for a Fair Business Practices Act violation, because that is not a consumer transaction. That's a business-to-business transaction. The other place, though, besides the consumer versus the dealer where you see an FBPA case is with the Secretary of State's Office of Consumer Protection. If they receive complaints, or if they're doing an audit or an investigation of a dealer, they might allege that that dealer is committing an unfair business practice. And on behalf of the state of Georgia, they might open up that investigation and proceed in a lawsuit against the dealer to enforce the Fair Business Practices Act as a state interest. So the Office of Consumer Protection under the Secretary of State actually has an interest in making sure that the businesses in Georgia are not committing unfair business practices. And to enforce that, they would open up a complaint against the dealer. Those can be messy, but they can also be negotiated. It just depends on the case and it depends on the situation. But the FBPA, kind of the highlights here to make this as brief as I can. Like I said, I could go on for a long time. Are number one, the notice requirement. Number two, it has to be a consumer transaction in a civil case. And number three is that the government can actually pursue an FBPA claim.